a statement on Fox News a little while ago saying, at my direction, every Department of Justice attorney is required to zealously advocate on behalf of the United States, and that any attorney who fails to abide by this direction will face consequences. So General Bondi, I guess the direct question is, he says he was fired because he didn't want to make an untruthful statement to a court of law. I have two questions. Number one,
This may look like just another tense exchange inside a Senate hearing, but it's actually about something much bigger than personalities or party politics. What's really being tested here is whether the Department of Justice still functions as an independent guardian of the law, or whether pressure, loyalty, and political survival have begun to redefine what justice means. Because when an attorney inside the government claims he was punished for refusing to say something he believed wasn't true, that's not just a workplace dispute. That's a challenge to the very principle that government power must operate under truth, ethics, and accountability. This raises broader questions about whether the system itself can correct course when loyalty begins to overshadow legality. In this video, we'll break down how this exchange exposes institutional stress points, what it reveals about internal culture at DOJ, and why these tensions matter for anyone who believes in democratic integrity.
Madam Attorney General, yesterday, Erez Ruveni filed a whistleblower complaint against the Department of Justice. As I think you know, he was a 15-year veteran of the Department of Justice. He received commendations during the first Trump administration for all his work at DOJ, but he filed a detailed account of his recent experience at the Department of Justice, saying that prior to his determination, that he was terminated after he refused to sign an appeal brief that was unsupported by evidence or the law. And he says, I didn't sign up to lie. In response to his termination, you made a statement on Fox News a little while ago saying, at my direction, every Department of Justice attorney is required to zealously advocate on behalf of the United States, and that any attorney who fails to abide by this direction will face consequences. So General Bondi, I guess the direct question is, he says he was fired because he didn't want to make an untruthful statement to a court of law. I have two questions. Number one,
What just happened is a collision between professional ethics and institutional power. A veteran DOJ attorney says he refused to endorse arguments he believed weren't grounded in law or fact, and paid the price. That matters because DOJ attorneys aren't political actors, they're guardians of constitutional fidelity. If their job becomes defending outcomes rather than defending truth, that changes the very mission of the institution. And if whistleblowers are punished rather than heard, it signals a culture where loyalty is rewarded over integrity. And that's where democratic safeguards begin to erode.
I assume you agree that zealous advocacy does not mean telling untruths to courts of law. And second, if that's not the case, what did you mean by saying he was not a zealous advocate?
Senator Van Hollen, this is all pending litigation, as you're well aware, and the timing of it, I can't discuss pending litigation. This is a whistleblower lawsuit pending within my office, but I will say the timing of it I find suspect, as he takes hits at Emil Bovee, who is one of the best human beings I know, one of the smartest, brilliant men I know, who will soon become a federal judge. And his hearing happens to be today, and I find the irony of the timing of it pretty remarkable, the lawsuit. But this had to do with attorney-client privilege information that was disclosed. I can't talk about the substance, but what I will tell you, and you have obviously my word, any zealous advocacy means to be done ethically and honestly, always.
What we see here is the institutional defense mechanism activating: legal deflection, procedural shields, and character reinforcement. Legally, she's within bounds not to discuss pending cases. But politically and ethically, this posture matters, because when credibility is questioned, leadership is measured not by how quickly they dismiss allegations, but by how committed they are to transparency and accountability. Framing the issue around timing rather than substance raises concerns about whether the institution is prioritizing truth-finding or damage control.
And that's what I mean by zealous advocacy. He also accused Emil Bovee of things that Todd Blanche, who is one of the best human beings I also know, my deputy attorney general, was in the room and said did not happen. But again, I wish I could get into greater detail. I can't because it's pending. But I stand by Emil Bovee and I stand by Todd Blanche every day, and I always will.
Well, Madam Attorney General, I will say that his account seems to have lots of information. So as you say, this will obviously be something that's litigated or reviewed through due process procedures. But I have to say that it's very, very disturbing.
This isn't being framed as an isolated grievance. It's being linked to a pattern of unease across government enforcement agencies. That matters because systemic discomfort suggests systemic pressure. When multiple officials feel ethically cornered, we're no longer talking about one complaint. We're talking about an institutional environment that may be drifting away from neutral enforcement toward political expectation. And when the people tasked with upholding law fear violating it, something fundamental is being strained.
Also heard from others in other departments who are responsible for implementing the laws of the United States that they feel uncomfortable about having been asked to do things that they thought were unethical. Let me go on to some of the budget questions, and I really want to follow up on my colleagues, Senator Moran and Senator Collins. But the DOJ grant funding is being sort of cut back on two fronts. One, in April, the department terminated hundreds of grant awards notifying grantees that their current grant funds were gone, effective immediately. That included law enforcement training grants, technical assistance awards, some dating back to fiscal year, I think, 2017. So question number one is, are you going to be releasing those funds? The second concern regarding grants has to do with the monies that were appropriated in this fiscal year, in March. And my understanding is that DOJ is withholding an overwhelming number of notices of funding opportunities, NOFOs, meaning that grantees who rely on these grants, including many who provide services to victims of crimes, are literally, in some cases, running out of money. For example, the department's biggest grant-making component, the Office of Justice Programs, has only posted one notice for fiscal year 25, NOFO notice. So if you could answer the question with respect to both those pieces.
Sure, and that's a very valid question, Senator. The notices will be going out in coming weeks about the grants. And we did cut grants by 6%, and I'm here to tell every senator, if we did cut a grant that you care about that is specific to your state, please contact me. I've turned on grants that were cut off. So please, if that happens, there's an appeal process, but you can pick up the phone and you can call me, and I would be more than happy to look at that. I never want to take away a grant that is actually helping Americans, helping victims, helping law enforcement, and we're looking at it on a case-by-case basis, and many of those are being appealed already, but you have my word, we will look at all of those, absolutely.
Thank you. And in terms
Here, the stakes transform from ethical culture to operational impact. When DOJ funding for law enforcement support, victim services, and community programs gets delayed or cut, trust isn't just abstract. It affects real lives. The message perceived is that priorities may be politically curated rather than grounded in consistent governance. When resources that communities depend on suddenly disappear or stall, it reinforces skepticism about institutional stability. And if administrative disruption becomes normalized, accountability weakens and public faith in justice infrastructure declines.
of the other piece of the question, when the notices for information will go out, because the fiscal year obviously is, running out, and we are hearing from lots of entities that are waiting for those notices so they can apply for the grant funding.
Yeah, yes, Senator. The notice of funding is consistent with our priorities, and they're finalizing it right now. It will be going out very shortly.
Very shortly. All right. Thank you.
It'll be posted on a rolling basis, too, I believe.
Okay. If you could just keep us posted on that. And I would appreciate it, Madam Attorney General, if you could have your team or respond to a letter that about 30 senators wrote to you on this topic of the prior fiscal year funds that were frozen.
I will make sure they look at that letter. I think we've received probably thousands of letters.
You've got lots of letters. But we really do need, in order to do our job, to get responses. Thank you, Mr. Chairman.
Attorney General.
Taken together, this hearing isn't just about one whistleblower or one attorney general. It's about whether truth still anchors the institutions that enforce our laws and whether power inside those institutions remains accountable to ethics rather than convenience. When internal dissent is seen as disloyalty instead of integrity, democracy loses one of its last internal alarms. Public trust isn't sustained by slogans. It's sustained by the courage of people inside the system to insist on honesty, even when it's inconvenient. And if our justice institutions want credibility, they must prove they protect truth, not punish it. Accountability isn't optional. It's the foundation of democratic legitimacy. Support independent journalism, support accountability, subscribe to Liberty Report USA.